Hi, I'm Beth Walensky, legal practice professor at the University of Michigan Law School, and this is the fourth video of four that are an introduction to CREAC. This video is about the A in CREAC, application, and at the end of the video we'll talk briefly about that last C, which stands for CounterAnalysis. So let's talk first about what the keys to effective application are, and then we'll look at some examples of how to use these keys and these principles in drafting the application section of your analysis. Now remember, the application is where you take the element or the factor and actually apply it to your client's facts. You tell your client what a court's going to do in its situation. So the first thing you want to keep in mind is in your application, you want to actually refer back to and rely on the rules and explanation. You will have just spent perhaps several paragraphs or more discussing the rules and explanation, and you certainly don't want to ignore that information when you get to your application. You want to use that information. You want to be specific when you do that in drawing comparisons to the case law. This is where you, the attorney, need to be doing the work for your reader instead of relying on your reader to figure out what the relationship is between the application and cases you've just finished describing. Finally, don't be wishy-washy. So what that means is don't tell your reader, well, here are a bunch of reasons that the court might decide X, but also there are these other reasons that the court might decide Y. That's not particularly helpful to your reader. If it's truly a close question, you can say that, but you need to explain to your reader why it's a close question. If you are pretty sure, but it's not crystal clear, you can qualify your answers by saying things like, it is likely the court will do X, or the court will probably do Y. But even then, you want to save that for circumstances where you have a specific reason to have to qualify your overall application. And we're going to go back to our imminence element that we've looked at several times now. So again, we start with the conclusion. Livingston will be able to establish that the harm she feared was imminent. You remember, I'm sure at this point, our two-sentence rule, which ends by saying that where the victim has a weapon within arm's reach, the harm is imminent enough to satisfy this element. Then we explain that rule with using Juno. For example, in Juno, the victim had a gun strapped to his leg. The court held that even though the victim didn't have the gun in his hand, he would have been able to unstrap and use it quickly enough that the harm was imminent. Now we're ready for the application, and that's these two sentences, or three sentences rather, at the end of the paragraph. So notice first that the application begins with the word similarly. That's a succinct way of drawing a direct comparison between my client's facts, which I'm about to discuss, and the court opinion in Juno that I just finished describing. These are really helpful ways of making clear the relationship between the application and the explanation. Let's look at some other examples of how to do that, of how to make those comparisons explicit. First, if you want to compare cases, if you want to point out ways in which the cases are similar or reasons why your client's situation is likely to have a similar result to the situation you just described in a court opinion, here's some language. In addition to similarly, which we just saw, you could say, like in Smith, and that could be the introduction, imagining here that we've got a case called Smith versus Jones. So let's pretend that's the case that we're trying to draw a comparison to. You could say something like this. Imminence is even more clearly established here than it was in Smith. That's drawing a comparison that's a little bit more specific. We're not saying that they're the same. We're saying that this is actually an even stronger case. Alternatively, you might do something like this. While the facts of Livingston's case aren't as strong as they were in Smith, she still satisfies this element because. Now, frequently what attorneys do is they distinguish cases. They explain how the outcome in one situation, your client's case, for example, is likely to be different because the facts are different from the opinion you just discussed in a legally significant way. So if you're distinguishing cases, you might say, unlike in Smith, or because the facts here are not as extreme as they were in Smith. Keep in mind, these are just some examples of introductory language. As you are working through cases, you might come up with a lot of different ways to be very specific about the relationship between your application, between your client's facts, and the court opinions you discussed in the explanation. So now let's go back to our imminence paragraph and look at the next thing that we do. After the word similarly, I have one short word here. I use the word and attorneys use the word here to signal to your reader that we're now talking about our client's case. Similarly, here. You would use the word there if you were referring back to a court opinion. Now I identify fact that is potentially problematic for my client, while Manning did not yet have the vase in her hand. I then go on to explain why that fact doesn't matter, or rather that fact does not mean that the imminence element isn't satisfied. She was quite close to it, that's the vase, when she stepped into the hallway. It would have taken a matter of seconds for her to grab the vase and throw it at Livingston. And I end with a very firm and straightforward statement of my conclusion. Therefore, this element is satisfied. Notice that I don't say it is likely this element is satisfied or this element is probably satisfied. Based on the rule and explanation that I pulled out and my application, this is an instance where I should be firm and not say likely or things like that. The last thing I want to point out is that I've used the actual names of the parties here, Manning and Livingston, when I get to the application. So this is unlike what I did with the explanation. Remember, when I write the explanation section, when I talk about the court opinions, I want to use descriptive labels, not the actual names of the individuals, because in that instance, the names of the individuals are unnecessary detail, and that's too much information to expect my reader to keep track of. However, when I get to the application, it is helpful to my reader to identify the individuals who I'm going to be talking about throughout this memo, Manning and Livingston, and to use their names consistently instead of using the generic victim and defendant. So let's look now at another example. This one is the reasonable belief of harm element. So remember, we have to imagine now that I've written out the rest of the CREAC analysis. I started with a statement of the conclusion that Livingston will be able to show that she had a reasonable belief of harm. And then let's assume that I've already drafted not only the rules, but that I've actually explained the rules. For brevity's sake, I'm not going to go through that here, so we'll pretend that there's an explanation for each of these rules. Now I'm ready to go on to the application of this element. So the first thing I want to emphasize, if it isn't already clear, is that you will notice that until I get to the application, there is nothing after the conclusion that talks about my client's facts. In other words, I start with a conclusion that says, here's what's going to happen in Livingston's case, and then I shift completely to rules and explanation, and nothing in there should really mention Livingston. It's confusing to the reader to jump back and forth. It's kind of like a tennis match. If you're going from rule and explanation to a little bit of application, and then some more rules, some more explanation, now I'm going to apply it a little bit more. Later on in the year, we will talk about circumstances where it might be appropriate to bring some application in early, but for now, the default that you should follow is state the conclusion, and then set aside your client's situation and don't mention it again until you have fully addressed and laid out the rules and explanation. Now that we've done that, we're ready to go on to the application. Now, there's a lot of text here. This might be a good place for you to pause the video, to stop and look specifically at what this application says, and in particular, look for places where the application draws explicit comparisons to the case law. So the application starts with a one-sentence mini-conclusion. A reasonable person in Livingston's shoes would have believed Manning intended to harm her. This takes the conclusion and makes it a little bit more specific using the rule. Remember, one of the rules that I have drawn out is that courts use a reasonable person standard. This helps orient my reader to the fact that I'm now shifting to application, and it puts the most important point, that key point, right up front. The next thing I do is then I go through the application by drawing on explicit comparisons to the case law and distinguishing cases, again, very specifically. Like the defendant in Sanderson, that's one place where I've told my reader I'm about to draw a specific comparison. Livingston was aware that Manning had a history of becoming violent when intoxicated. In fact, Livingston herself had been the target of Manning's drunken aggression in the past in very similar circumstances. That makes her fear of harm even more reasonable than that of the defendant in Sanderson, who merely knew of the victim's drunken aggression against other people. Notice there, again, it's a very specific comparison where I'm saying the facts here are even stronger than they were in this other case where the court held this element was satisfied. Moreover, Manning pursued Livingston even after Livingston tried to get away by retreating to her room and locking the door. Now, I'm about to make another direct, specific comparison to the case law. That makes Livingston's situation similar to that of the defendant in Juneau, who had unsuccessfully tried to run away from his pursuer. Manning went so far as to kick in the door to continue her attack, and as a result of Manning's relentless and violent pursuit, it was reasonable for Livingston to believe that Manning was not merely ending the attack when Manning tried to walk out of the room. So now that we've seen an example of how to draw explicit and specific comparisons to the case law, let's look at an example of what not to do. Remember, you want to avoid making your application so general that you are relying on your reader to do a lot of the work of drawing the connections to the case law. So this is an example of what not to do in your application. A reasonable person in Livingston's shoes would have believed Manning intended to harm her. Like the defendant in Sanderson, Livingston knew that Manning had a history of aggression, and like the victim in Juneau, Manning pursued Livingston. Therefore, Livingston's belief of harm was reasonable. Now, that starts to get at some decent application, but I've left too many of the details, too many gaps left open for my reader to have to fill in by going back, for example, and looking at the facts of my client's case, reminding herself what the facts were in Sanderson. I don't want to force my reader to do that. It's my job as the attorney writing this memo to do that work for my reader. Okay, now let's look back at our overall application for the reasonable belief of harm element. We have one more paragraph of application. And here's what it says. While it is true that Manning's action in walking out of the room could have indicated that she was ending the attack after seeing Livingston's gun, Manning had kicked in the door only seconds earlier and still appeared angry. That makes Livingston's situation unlike that in Crabapple, again, drawing a specific distinction between the case law, where the victim had calmed down several minutes earlier and remained calm at the time that the defendant stabbed her. There was enough uncertainty about Manning's intent to make Livingston's fear reasonable. So I think it's helpful to think of this as application, but you could also think of this as counter-analysis. Why? Well, notice that what I've done here is that I've considered a potential fact that might make it seem like this element could come out the opposite way that I have suggested it would. And I've addressed that here in this last paragraph. I don't want you to get too hung up on whether this is application or counter-analysis. You could truly think of it as either. I do, however, want to use this as an opportunity to talk briefly about counter-analysis. This is something that you're going to get into more as the year goes on, but there are a couple of things that can help you for now. So, some keys to keep in mind. When you have a counter-analysis, you always want to explain why the counter-analysis doesn't alter your conclusion. This is part of the not being wishy-washy principle that I introduced at the beginning. It's not helpful to your reader to start out by saying, here's what's going to happen and here's my application. Oh, but there's this other thing that might also happen. So the counter-analysis is where you take your conclusion and say, there are some things that might make you believe that the conclusion is not as clear as I suggest it is. I want to explain why you shouldn't worry about those. You should think of the counter-analysis as your supervisor or your client, for example, saying to you, well, did you consider these other facts? And you want to have already said to that person, I've considered all of the possibilities, and here's why my conclusion is what it is. You also don't want to include unnecessary counter-analysis. In other words, your job isn't to look for straw man arguments, weak arguments that almost certainly are irrelevant, just to show that they don't apply. You only want to address counter-arguments or counter-analysis that actually seem to have some basis, some potential to be of concern, but that not ones that are so easy that they don't even merit mentioning. In other words, we're back to our principle that we want to include necessary information and not unnecessary information. And finally, don't save any of your application in order to have a counter-analysis. In other words, it is absolutely fine, and in fact will usually be the case, that you will finish your application and you won't have that final C for a particular element or factor. So you should never feel as though you need to hold back discussion from your application so that you have something to put in a counter-analysis. If you finish the application and you've said everything you need to say, then that's great, you're done with that element. And that is the end of our overview of the application and counter-analysis parts of CREAC. And that is also the end of the 4 videos that introduced you to CREAC. Now you're ready to go off and try these things yourself.